All right, welcome back to MEA 425 Media Copyright and Licensing. We have made it pretty good ways in this class. We're coming up to the halfway point, and now we're starting to look at moving away from a sort of general view of laws and legal concepts that help us understand how to make money off of intellectual property, what intellectual property is, to the specific sort of recognition of the publisher, music publisher, as a music industry player, what their process is, and now starting to look at the license types that make up their catalog, or not catalog from a song perspective, but their sort of day-to-day operations, how they make money, what instruments, legal instruments they use to do that. And so the license is, I would say, primary among those. And they are contracts. They satisfy the basic requirements for a legal contract. So there's, two different parties that have an agreement for one thing in exchange for another, and they consent to that agreement with a signature to execute the agreement itself, meaning that it's legally valid. So when we look at licenses as contracts, they're the same in that respect because they are contracts, but the operation of the different licenses, what kind of use, I should say, of music will allow for money to come, start to flow, brings us to these different license types. And so public performance is where we're going to start today. And we will move through. If you look at the calendar here, we're up here. And we'll move through to mechanical rights and synchronization rights. So these are the top three. So this week and for the next 2 weeks after, these are ranked in order of how much they are worth to the music business, to the music publisher, to music ownership. Public performance being the most valuable, then mechanical, then synchronization. So that's why they're in that order. Let me get my beautiful face back on here. There we go. So let's get started. All right, so we want to look at performance licensing from a historical and legal context, define what's meant by public performance. We think we understand, but from a consumer point of view, it's actually a little too simplified. And so it's a touch more nuanced than most people would expect. Then we're going to look at performing rights organizations. Our presenters have done that for us, so I'm not going to be too repetitive. But then we'll look at their ability to grant licenses, some considerations for owners who are granting the right of public performance. When does the PRO kind of step in, and when are they not necessary? And then how do the PROs pay out, or how do the users pay in, and then how do the PROs pay out? So once again, PRO is a performing rights organization. And when you look at the performing right itself, you'll remember that music compositions themselves were adopted in the U.S. and actually before Europe in 1831. And a few years after that, 20 years that is, so one generation, 25 years later, you've got plays are protected. And so this is an important combination that songwriters took yet another 39 years after plays, the protection of plays, to recognize that the songs in the plays also had value. And so, and the performance of those songs should also be protected. Excuse me. And so the performance right itself, we find 1895 coming about in the United States. Now, in this case, France and Western Europe are in advance of us. And so Europe protects the composition in 1842, but, excuse me, they actually have their very first PRO before we even have the performing right recognized. So the Société des auteurs, compositeurs et éditeurs de musique is SACEM. That is the very first performing rights organization, 1850 out of France. In the United States, we're another 60, almost 65 years after that, which puts us to 1914 with ASCAP, which is our first performing rights organization. So we'll talk more about the organizations and what they do later, but just a chance to see a little bit of the history. The emergence of the performance right is sort of triggered by the combination of music and plays, where you're getting, that's the highest concentration of money right there. In the performance domain for music would be plays. And so once again, you see the law sort of reacting to these, what's happening on the cultural scene. Updating to just a couple of years ago, in the digital era, the consent decree is a important sort of wrinkle in the law when it comes to the performing rights organizations, because they have traditionally monopolized a lot of the processes when it comes to public performance. And the consent decree basically limits the powers of the PROs by enabling owners and users to license public performance directly between them. And so you don't have to pass through, it's kind of like eliminating a middleman. You don't have to pass through the PRO in some situations. And so those situations are exemplified by the source license and the direct license. And so example of a source license would be when you've got a film owner or a television program owner, script writer and producer who have not yet gotten a deal with a network, and but they want to use music because of the fact that airing of that television show is considered a performance or movie. Those are both forms of public performance. Those deals can go between the publisher and the author on one side as the ownership group, and then the we'll say the owner of the film on the other side, without having to go through the PRO up here, right? So that's going to make a little bit more sense, I think, once we get to looking at what the PRO does. And the direct license is the exact same thing, but just for like a streaming service, for example. That allowed the streaming services to negotiate performing rights directly with the owners instead of requiring mediation by the performing rights organizations. Let's see. Okay, so this is actually where we belong now. So what is public performance? So there are two sort of origin stories that bring us to the story between France and the United States, and it's redundant, right? Meaning that the same basic things happened. So in the 1840s in France, you had a composer walks into near the theater district in Paris, walks into a cafe, orders a drink, and the drink is a little bit more expensive because of there are musicians performing, and the composer realizes that the musicians are paying for are playing one of his tunes that is affiliated with one of the theaters in the area, right? So it's a popular song of the day, and the composer's like, why should I have to pay extra to hear my own song performed by these guys or anybody for that matter? So he takes it up with the bar manager, who refers him to the owner, and they get into an argument or debate about it. The case goes to court in Paris, and lo and behold, the performance right comes out of that, as well as SACEM, which is once again the Society for Authors, Composers, and Editors of Music, or something like that, SACEM. And so the job there of SACEM, of course, is to protect the rights of the composers, for the performance rights in particular. Now in the United States, update at 60 years, and you've got some of the members that ended up founding ASCAP are in a restaurant called Shanley's, and one of their songs in a theater district, and one of their songs is played, and the exact same sort of situation happens. They recognize that this is an unjust situation, and they form a performing rights organization. And so in both of those examples, you've got the public performance is a concert, right? It's a performance of musicians that are playing instruments, either acoustically or through an they wouldn't have amplifiers back then, but through a PA system. That is the basic definition, the first definition that most people would think of what's a public performance. However, there is also a second meaning. Second meaning of public performance is a broadcast of a song or recording. Now, we're interested on the composition side here, because the players on the recording side, that's master use. That's later in the semester, so we're not worried about the public performance of records right now. Just the composition. So what do the author and music publisher, what are their interests, and how are they protected here? And so you look at radio, TV, movies, online, whether it's interactive media like Spotify or non-interactive media. Interactive, you get to choose what songs you want to hear. Non-interactive media, like a streaming radio service or a podcast or something like that. And so both of these, you have to understand, both of these together make up what's referred to as a public performance. Now, when you look at the impact of these cases, and this is coming out of, once again, the 1800s. Paris, the Parisian authorities saw rights in terms of large rights or grand rights, des grands droits, right? High culture being reflected in opera, Broadway, classical compositions, quote, serious music, and then petit droit, right? So the lesser, smaller rights underneath, small rights. And so this is popular culture. So it's restaurants, cafes, saloons, and clubs and things like that. Back then, it was a real class differentiation thing. You had to understand what was serious and what was common and of the people or whatever. This is a European tradition that in the United States has completely turned on its head, because nothing against classical music, but they lose oftentimes more money than they make. The old saying is, it's the art of losing money gracefully. And the petit droit, right, the small rights, venues out to music clubs, even music festivals, if it's popular music, you're now measuring that in the billions of dollars easily annually, $20-30 billion, the value of the popular music industry in the United States annually. And so the PROs were initially set up to act sort of as a police over these venues, do they have the right to perform songs, the songs that are included as part of the show? And so this performing rights organization as police is really the original idea to make sure that a venue, whether it's high culture, oh yes, I would love to have some Grey Poupon, or low culture, you can eat that bratwurst, are both protected, are both protecting or paying for the right to perform music. Good. Okay, hold on a second. All right. All right, so not so worried about the yeah. Hey Bear versus Shanley's, I guess I just want to point out, this is a court case that precedes the founding of ASCAP, just like the one in France preceded the founding of SACEM. And so there are certain, similarities and differences. You're really not responsible for knowing that, but you should know that Hey Bear versus Shanley's is a court case that led to the founding of the PROs. Good. Okay. Now, so in terms of what a PRO is, obviously performing rights organization, we've been talking a little bit about them already. Best described perhaps as an industry middleman. You've got, or middleman, but you've got, these are the US PROs, right? CSAC and GMR, much, much smaller. ASCAP and BMI together represent 98% of what's referred to as the American Songbook. So probably close to 20 million songs by now are in their catalogs, which are, they're not publishers, but they are industry middlemen or clearing houses, right? And so what they do is, you imagine every radio station that there is in the United States. So every minute, they're going to play, choose a minute of the day, right? You've got 3,000, say, radio stations in the United States. That's just a guess. And they're playing one song, right, at that any given minute of the day. If not for the PROs, the managers of those radio stations would have to have a written agreement individually for their radio station to play that individual song, right? And then the next song that came up, you'd have to have a new agreement. And so if you play 13 songs an hour, that's probably way high, probably closer to 7. You'd have to have 7 agreements over 24 hours. You can see it adds up, right? That's 200 to 300 songs a day probably. And you'll remember from split copyright that each of these songs may have 5, 6, 7 owners. And so you have to then track down each of those owners for each song. So you may have, thousands of contacts to make just to get through a day. And so what the PROs do is, you've got all of your radio stations, venues, and broadcasters on one side of the screen here. And over here, you've got all of the songwriters that there are in the United States. And so all of the agreements back and forth between those two are centralized in ASCAP, BMI, CSAC, and GMR, meaning that all that a radio station has to do is say, I want to have access to your catalog, and they turn around and based on how far, how many people that radio station reaches, that's going to be the price of that license. But they'll issue what's referred to as a blanket license that says you can, for 1 year, you can broadcast any song that we have. So radio stations typically will have to have 4 different performing rights blanket licenses: ASCAP, BMI, CSAC, and GMR. And then they can play whatever songs you hear on the radio, basically. And so they assume the burden of tracking public performances and they charge those users, right? So the concerts, but also the broadcasters, radio stations, etc., concert venues, in order to have access to the music or to the compositions, and then they collect that money and then redistribute to the writers and to the publishers. So that's why it's an industry middleman or a clearinghouse. And so you've got the licensor, as usual, over here, which is going to be the ownership cluster, usually the author and the publisher as an ownership group. And then you've got all these users over here. And so the clearinghouse is in the middle, takes the requests from the users, and then tracks the licensors, gets permission, collects the money, and transfers it out to the owners. Now, the blanket license, once again, is that sort of one license for the entire catalog for a year. It's typically how they work. And so 4 blanket licenses, right? One for ASCAP, BMI, CSAC, and GMR, and you're set. Now, when it comes down to licensing for digital, it's important to recognize the difference between an interactive and a non-interactive performance rights license for digital use, meaning that on the non-interactive side, it's very similar to streaming for radio. And so the prices are similar to radio. On the interactive side, however, it's a lot different because consumers have the choice to listen to specific songs. And so they choose those songs. And so there's a premium that you pay for the interactive performance license that's actually higher than the non-interactive. Okay, there are some exceptions. As usual in life, we've already learned about fair use. So in a situation of face-to-face teaching, I can have a song performed without needing a license for that, or I can play a song myself. Or in the course of worship, or if there's no direct financial advantage attached to the performance, or if it is for government or instructional use. These are parts of the test, the fair use test. And so those are all typically exceptions. Now, there are also exceptions that come in terms of how big your facility is or what kind of, PA system or, radio you've got in there, stereo system or sound system, I guess is the proper word there. So the Fairness and Licensing Music Act came about and said, some smaller establishments, usually under 2,000 square feet or slightly bigger if it's a restaurant included, may be exempt from paying performing rights organizations. If they also have, under a certain amount of speakers, right? I think it's 4 per room, but if you're interested in those details, the Fairness and Licensing Music Act is what you would need to look over after that. Now think about, going to the barbershop, they've got a radio in there. So that's referred to as a home style receiver, meaning that, which is actually a pretty good stage name. But anyway, if that's another exception for performing rights. So you're not making money off of it. It's just like background music. You've got your radio turned on in the background. It's a small one like you'd find in a house. And so that's an exception for getting around paying performing rights organizations. Now, for those who don't pay performing rights organizations and should do so, the penalties can be quite stiff. A couple $1,000s, you can have multiple warnings, and then you can get shut down. And that's what happened to the bottling company here in Hattiesburg. I think that was 2013. 14, 15, somewhere in there. They thought that it was a joke. You don't have to pay the PROs. And the folks came in there and gave him multiple warnings. And then the fine was big enough to shut them down. So, but once again, on the collection side, the PROs are going to, get paid usually by a blanket license fee. And those blanket licenses are paid by venues and broadcasters for the right to publicly perform the songs in the various PROs, databases or catalogs. And then cinema and dramatic stage, they don't use PROs. So they do have the right of public performance, but they're directly negotiated between the owners and the. It's usually a different type of a rights package we're going to get to. Broad rights is a like all-inclusive rights package for cinema, and grand rights is the name of the all-inclusive package for the dramatic stage, which is basically like when you're doing plays and things live on stage with actors and actresses like Shakespeare, that's referred to as the dramatic stage. So you've got these larger rights packages that are negotiated separately and directly, and so the PROs are not necessary in those situations. Now on the distribution side, usually they've got different ways to monitor what's being played in terms of broadcast. They used to call people, radio stations up for a report of what they played last week. Now they'll take random samples. So a sampling method. You'll see that later on our PRO worksheet. I'll go over that in a second, but it's how do they find out who they have to what was played on the radio, for example. And usually that's done by digital fingerprint, which is if you've ever worked in a Pro Tools session or GarageBand, there's usually a waveform that's printed out on the screen that you can edit that represents the music, and so it's kind of the fingerprint. Every song has its own fingerprint, and so they can use digital technology to track what's been played. So it's much more precise now. And so once they get that information, then they have got a formula. If it was played like at 3 o'clock in the morning, for example, on a radio station that serves a very small population, that's different than if it was played at 9 o'clock in the morning or 7:30 in the morning, which is the primetime drive. It's one of the most valuable radio slots there is, the morning drive, I mean. Then the formula is going to weight that use and it'll pay out higher, right? And so once they figure out, how many times a song was played or, how much rotation it's getting through their digital sampling method, then they will apply the formula, the weighted formula to it, and distribute directly half to the publisher and half directly to the author. And so it's one of the few forms of music royalties that is not pass-through income that must go to the publisher and then the publisher splits it off. Instead, it's direct to the publisher and direct to the songwriter in two streams that you've got the PRO up there. So they do have traditionally a lot of their fingers in tons, a lot of the music business. And so as a result, there's a lot of power that's associated with the PROs. And so when you see those consent decrees, for example, that's sort of other parts of the industry kicking back against that power to, operate in a more direct, less mediated way. Okay, so here are some of the terms that we use. The consent decrees allow for direct licensing and a way to get around the PROs. The Fairness in Licensing Music Act is one example of how you would not have to pay for the performance right because your venue is too small or you don't have enough speakers or whatever it is. Haybert versus Shanley's is that United States court case that precedes the formation of ASCAP. The direct versus source licensing comes from the consent decree, which basically allows for, in the case of the source license, it's the program owner that contacts the owner of the composition. In the direct license, it's the program network or broadcaster that contacts for permission and negotiates that use. And don't forget that a performance sampling is not sampling like we know it from little bits of a recordings. That's circle P sampling. The sampling method that I'm talking about here is how does the PRO figure out what was played on the radio. And so they'll pick a random week and take, figure out what was there, and that's a sample, right? A sample batch of that represents, they can extrapolate an idea of what's on the radio based on that sample. So anyway, that's your presentation on our performing rights organizations, and well, really just the right of public performance. And so, what I have for you to kind of collect this information is a performing rights worksheet. And so this is going to be used more as a study guide. In other words, you'll need to have this information collected and easy to access in order to, be prepared for the next test. And so what are the names? What does ASCAP, BMI, and CSAC stand for? So I filled out all of the CSAC stuff. It's a smaller one. You get this information at ASCAP or BMI, .com or .org, whatever it is, the website. Oh, I've got a friendly puppy dog here. Say hi, Louie. Oh, he needs some attention. So about these, I'll take you through a few of these, but what does the acronym stand for? And then what is the job of a performing rights organization? I just described that to you, right? They're oftentimes referred to as a clearinghouse, but what does that mean? What date was ASCAP founded? I gave you that one in the presentation. BMI is a little bit later, also in the 30s. It's the youngest one. How many members, right? So you got 30,000 members here. These are closer to 250,000. But just go, this is designed to get you onto their website, so you browse around a little bit. You figure out what their sampling method is. All of this is online, so just browse around. This is a way for you to discover what the performing rights organizations are, how they compare to each other, how many songs are in each catalog. They tell you that. This stuff is very easy to find. The sampling methods can be a little trickier to find, but we'll go over that. How much does it cost to join as a songwriter? How much does it cost to join as a music publisher if you wanted to be self-publishing, right? This is how you set up a music publisher. How often do they pay the royalties? So CSAC is quarterly. Are these guys every 6 months, annually, or quarterly as well? What's the name of their song database? So if you wanted to use ASCAP or BMI to find out who owns a certain song, which is a common way to use them, then they have a database. And so the CSAC one is called Repertory. It's just right there on the front page, the welcome page of the website. And you can search song titles and figure out who owns, who the publisher is, who's the songwriter, if there are multiple songwriters, who owns how much percentage. Very useful information there. How many foreign affiliates do they have? So internationally, these are other PROs that report with them and they share information with. And then who is the CEO, or who's the leadership, right? So Christos Bavados and Blackstone Group own CSAC. Well, how about these? What about noteworthy artists that are on ASCAP and BMI? On CSAC, you've got Mariah Carey, Bob Dylan, Adele, Robert Johnson, and Neil Diamond. So this is a way to collect information and to demonstrate knowledge and the ability to compare and understand your PROs at a little bit deeper of a level than someone who just knows that they handle performing rights and you get your blanket licenses from them. So that'll give you a chance to kind of browse their websites and do a little bit of digging. Okay, so if you've got any questions, please post them in the comment section so that everyone in the class can benefit from our exchange. And go ahead and print out that information and get it ready, the worksheet, so that you can have, sort of be done, I guess, with what I expect you to have from the performing rights side. All right, good luck.